Before discussing this topic, critique of the Article 370 judgment of the Supreme Court, few things I need to tell you with respect to the previous ED which we discussed, torture. One thing is that don't limit your analysis of torture only to the police. There have also been accusations against security forces, including the armed forces, especially the army, where this AFPA is being enforced. Right, that's one. Not only that, there are other investigative agencies, including CBI, Enforcement Directorate. Right. So, recently there have been allegations against officials of Enforcement Directorate using coercive methods and torturing people to accuse the opposition leaders and others, etc., etc. In fact, in the Delhi excess scam, we don't know whether there is a scam or not, but now that is how it is being referred to. These allegations have been raised against officials of Enforcement Directorate. Apart from that, you know that in Manipur, in Kashmir, etc., recently, I think 3 civilians were alleged to be tortured by the armed forces, especially the army, in Jammu and Kashmir, and their dead bodies were recovered from a site where this encounter happened, etc., etc. And even the defense minister has assured justice to victims. And there has also been a video. We cannot verify the authenticity of that video, but the point I am trying to make is that there have been allegations against other forces, other agencies also. Number two is that the changed criminal law system, not exactly changed, they will notify that this criminal laws, Bharatiya Nyaya Sanhita and others. One troubling issue with respect to this BNS is this BNS will replace the IPC. One troubling issue with respect to BNS is that it enhances the period of police custody or police remand. From I think earlier it was, in general, the police remand was for 15 days. Now it can be extended to I think 90 days. 90. Under some conditions, some circumstances. So this provision for enhancing the police custody can also lead to furthering this culture of torture. And as you are reading newspaper, you must have heard about that, the allegation leveled by some accused in the parliament trespass case, they have alleged that, good evening Shida, they have alleged that they have been tortured and even given electric shocks to implicate the opposition leaders, etc., etc. So these two things I wanted to tell you, that your analysis should not only be limited to the police, and this what we say, the new bills or new laws which have replaced. And not only that, I would add one more thing, there are some special laws dealing with organized crime. If you see Maharashtra Control of Organized Crime Act, this act provides that if confession is made by an individual before an SP rank officer, then the confession is valid as evidence in a court of law. Recently, the Supreme Court has said that SP can be additional SP also. The point I am trying to make is that there is a huge chance of exploitation or misuse of this provision. Right. Anyway, now come back to this topic, Article 370, Judgment of the Supreme Court. There are some issues which, given a chance, I would not teach. Because we would have, personally speaking, I would have thought that such judgment should not have come at all. I would not prefer to teach this topic because the judgment does not do justice to the constitution as well as the people of Jammu and Kashmir, and does not do justice to those individuals who believe in democracy and federalism. But we are all caught up in our destiny and we have hardly any chance to escape it. I will be teaching you the judgment of the Supreme Court. From a historical perspective, we will study the Article 370. And after that, we will see the decisions of the Union government. Then we will see the judgment of the Supreme Court. And we will see then the criticism of the judgment. The material which you have may not deal with the aspect which I am going to discuss. Because this is one of the difficult topics to teach, not only that difficult topic to make. In fact, former judges, including Honorable Madan B. Lokur, when he gave an interview to The Wire, he told Karan Thapar that it's a highly complicated judgment, difficult to find out what exactly the court wants to say and how the court has reached its conclusion. According to him, more than 200 pages are redundant. Right. But it is our duty, responsibility to teach you properly. So, we have made it easy for you. In fact, I am trying to make it easy for you. There are multiple nuances in this case, multiple issues which need to be discussed, which will take some time. Right. Whenever you have some doubts in between, you can ask directly. Because this, the dimensions or aspects of Article 370 are spread on over multiple sources. You cannot get the entire issue in one place. So I have tried to gather it from multiple sources and to present it to you from a layman's perspective, so that you will understand it. You know that in December 2023, a constitutional bench of the Supreme Court gave this verdict as far as Article 370 is concerned. The Supreme Court upheld the decisions of the Union government with respect to Article 370. We will deal with the judgment later. Before dwelling into the judgment, let us understand what is Article 370, the history of Article 370. A historical perspective is necessary to understand the impact of the judgment and various other aspects of the judgment. Article 370. Before discussing Article 370, let me give you some developments which happened during 1947 and 48. As you know that the Indian Independence Act 1947, which incorporated the Mountbatten Plan, provided option to the princely states in India. They can either be part of India or Pakistan or remain independent. Almost all the states joined India by signing various instruments. Jammu and Kashmir, Maharaja Hari Singh, the ruler of Jammu and Kashmir, decided that he wanted to be an independent country. But because of the external aggression, the threat posed by the invading Pakistan militia supported by the Pakistan state, and also due to the internal political development for democracy and representation, etc., Maharaja Hari Singh signed the instrument of accession in October 1947 with the government of India. Pre-independence, the nature of relation between the British Indian government and the princely states were governed by 1935 Act. In 1935 Act, the British government entered into various agreements with various princely states. As far as Jammu Kashmir's relation with the British Indian government was concerned, 4 subjects control over 4 subjects were given to the British Indian government. When you see some sources, generally newspapers and others, they will tell you that the British Indian government, or later after independence, the Indian government had control over 3 subjects: external affairs, defense and communications. That's wrong. There are 4 subjects. Fourth one was ancillary. That is why I have here the instrument of accession of Jammu and Kashmir. Right? If you want to have the original copy, there is in the wire, there you will find it. The matters with respect to dominant legislature may make law. I'll explain that later. For the time being, understand defense, external affairs, communication, ancillary. 4 subjects. Right? So the instrument of accession which the Maharaja Hari Singh signed with the government of India essentially repeated the nature of relationship between the princely state of Jammu and Kashmir with the British Indian government. So if you see the instrument of accession, you will find that it simply says that the relation which existed, or the control of the British Indian government which existed during the operationalization of 1935 Act continue within instrument of accession, and those subjects are appended in the schedule of the IOA. Instrument of accession was signed. Remember, almost all the other princely states also signed instrument of accession with the Union. Instrument of accession is not only signed by this Jammu and Kashmir state. So instrument of accession was signed by other princely states also. So instrument of accession essentially provided for acceding 2 of these princely states to India. Most of the other princely states, after signing instrument of accession, signed a merger agreement with Union of India. So once you merge, then you are part of Union of India. Earlier, instrument of accession decided the nature of relationship, limited to those 4 and others. But when you merge it, then you are integral part of the country. Jammu and Kashmir state did not sign merger agreement. It signed something called instrument of accession. This instrument of accession governed the nature of relationship between India, the Union of India, and the state of Jammu and Kashmir. It was signed in October 1947. But in January 1948, the government of India approached United Nations. The government of India said the Pakistani marauders, the militia, supported by the Pakistani army and the state, are creating problems to the people of Jammu and Kashmir. When the UN was looking into this aspect, there was also movement within the state of Jammu and Kashmir for more democracy, representation, etc. This is also a period where the Constitution of India was being made. In order to provide a more formal relation between the Indian Union and the state of Jammu and Kashmir, the Constituent Assembly decided that we should have an article in the Constitution. This instrument of accession is not enough. We should further formalize the nature of relation, the framework of engagement between the state of Jammu and Kashmir and the Union of India. Couple of months before the enactment of the Indian Constitution, draft Article 306A was added into the Constitution of India, which later became Article 370. So Article 370 formalized the agreement on nature of relation entered by the Government of India and the Government of Jammu Kashmir through instrument of accession. But Article 370 was added under this note or marginal note, temporary provision. So Article 370 was seen as an interim arrangement which provided a framework for the relationship between the Government of India, the Union and the state of Jammu and Kashmir. We will deal with this issue of temporariness or this temporary provision later. Alladi Krishnaswamy Iyer, when he introduced this draft article in the assembly, there were concerns that why are you introducing this article? He said that the state of Jammu and Kashmir is not ready for full and final integration with the Union. He said that there is war in that region. And there are also some concerns with respect to the United Nations intervention. He said it's an interim arrangement that governed the nature of relationship between the Government of India and the state of Jammu and Kashmir. The actual arrangement, actual framework of governance, actual framework of relationship will be determined by a Constituent Assembly of the state of Jammu and Kashmir. The provision for a Constituent Assembly was incorporated in Article 370 of the Constitution. So,
provision for the Constitutional Assembly of Jammu and Kashmir.
Jammu and Kashmir, yes. And this Constitutional Assembly will decide the further nature of relationship between who? The Government of India and the state of Jammu and Kashmir. But as you know, it is very difficult to bring a Constituent Assembly and to make a constitution. It's a time-taking process. So, there must be some interim arrangement, which was Article 370. The Constituent Assembly of the Jammu and Kashmir, state of Jammu and Kashmir, was set up in 1951. It sat for 5 years. It adopted this constitution in 1956, which came into force in Jan 26, 1957. After that, Jammu and Kashmir Constitutional Assembly was what? Dissolved, because making of the constitution is done. Before explaining what the Constituent Assembly through a constitution in Jammu and Kashmir entered into, before explaining the nature of relation which the Constituent Assembly through the Constitution of Jammu and Kashmir entered with the Union of India, I want to explain some aspect of 370 itself. Let us understand some content of 370. What exactly 370 is? Because according to the popular perception, 370 has been a temporary provision, an interim arrangement. Interim arrangement till the Constituent Assembly was made, and Constituent Assembly through the Constitution determined the contours of relation between the state and the Union. Article 370 essentially did the following. Article 370 had 3 clauses, clause 1, clause 2, clause 3. Article 370 clause 1, Article 370 clause 2, Article 370 clause 3. The essence of Article 370 are as follows. It applied Article 1 of the Constitution and 370 of the Constitution to the state of Jammu and Kashmir. So 1 and 370 made applicable. Article 1 says what? India is a union of states. So in that union of states, this Jammu and Kashmir is a part. So Article 1 and the provisions of Article 370 was made applicable to the Jammu and Kashmir. Article 370 provided the power to the Parliament to make laws on those subjects in union list and concurrent list. Those subjects in union list and concurrent list which correspond to the subjects in instrument of accession. Instrument of accession, these many subjects, 4 subjects and under them sub-fields. So if you say defense is a comprehensive term. It will have this, what we say, naval, military, air force, etc. A lot of things are there. Parliament has the power to make law in union list and concurrent list which correspond to the domains or areas in IOA. But which all subjects fall under union list and concurrent list will be determined by the President after consultation with the state government. The President will consult the state government for determining which all subjects, which all areas correspond to the 4 major subjects. In the Constitution, Schedule 7, List 1. List 1 we have defense, etc. So there will be this entries and that entries, they will match which correspond. Consultation. Then the President will declare. Then Parliament will have the power to make law, right, in union list and concurrent list. Please repeat. Parliament has, I am using the word has. Now, you know, everything is changed. But anyway, Parliament has the power to make law in union list and concurrent list, and this law-making power correspond to those items in instrument of accession. But we have a list 1 and list 3. So, which all items correspond to those lists? There are items here. If let's say the word defense in list 1 might have a different composition, or the interpretation of defense can be different. So whether these items correspond to those interpretation, who will decide? Consultation with the state government. The President will consult with the state government. Then after that, law-making power. Cyber defense. I am giving an example in order to make you understand. Cyber defense or cyber crime. Space defense for that matter. Space force. Hypothetically speaking, let us say Article 370 is in force. So, in that list 1 of the Constitution, defense is there. But you cannot find space force here. Space or cyber defense. But the word defense can be interpreted. Now, if the Parliament wants to make a law on the cyber or space force, then the President will have to consult with the state of Jammu and Kashmir. This is how the process. Right, Akshita? Now, what about those matters which are not part of this? Parliament can make law in union list and concurrent list, but only 4 is there. What about other matters? Can the Parliament make law in union list and concurrent list which do not correspond to these 4 matters? Parliament can make law. Yes, Parliament can make law, but for this, concurrence of the state government is required. Concurrence is the word. Law-making within the confines of instrument of accession, consultation. Law-making outside the boundaries of instrument of accession, concurrence with the state government. Are you getting what I am trying to say? Here you see defense, external affairs, communications and ancillary. Let's take this concurrent list. Electricity. Electricity is in a concurrent list. Electricity is not part of this. So Parliament can make law and make it applicable to Jammu and Kashmir. Yes, the President, the Parliament can do it provided there is concurrence for the state government. If no concurrence, then it cannot. In both the cases, President will order, preferential order, we'll discuss that later. The preferential order will specify, yes, having consulted with the state government or having got concurrence with the state government, the Parliament is making law in this, etc., etc. That can be done. Now, what about the non-legislative aspects of the Constitution? We are here only dealing with the legislative aspects, law-making power, law. The Constitution of India is not only law. There are multiple other aspects, administrative, executive, and multiple aspects of the Constitution. What about them? The non-legislative aspects of the Indian Constitution can be made applicable to the state of Jammu and Kashmir, provided those non-constitutional matters correspond to the instrument of accession. You see, this is not only a law-making power. You will find different provisions with respect to this in the Constitution too. Let me give you an example here. External affairs, let's see. Admission, communication, post, telegraph, telephone, wireless, broadcasting, federal, railway. Right. There is a provision in the Constitution which says that the center can give direction to the state government to protect the railway. Now, it is not a legislative aspect. Can it be made applicable? It is governed here. Consultation with the state government can be made applicable. Now, what about others which are not part of it? Concurrence for the state government. Concurrence of the state government. That's a fundamental right. Part 3, not given. The point I am trying to make is this. Article 370 fundamentally bifurcated, delineated the nature of relation between India and state of Jammu and Kashmir. One aspect of that relation is legislative relation. If it is within the boundaries of IOA, then consultation with the state government. Outside the boundaries of IOA, then concurrence with the state government. Non-legislative aspects. Boundaries of instrument of accession, consultation with the state government. Outside the boundaries of IOA, concurrence with the state government. So, in legislative aspects or the non-legislative aspects, preferential order, after consultation, etc., President can promulgate an order. President has promulgated an order in 1950. Preferential application to Jammu Kashmir constitutional order, 1950. The first order which was promulgated by the President simply means constitutional order, 1950, January 26, when the Constitution commenced. Later, in 1954, an order was promulgated. The 1954 preferential application of the Constitution to Jammu and Kashmir order. So, preferential order 1954. This preferential order 1954 is the fundamental order, the mother order, you can say. This 1954 order have been amended later from time to time. For the time being, understand the 2019 orders for the President, we will discuss that later, have replaced this 1954 order. Now come back to this 1954 order. The 1954 order extended the legislative and non-legislative aspects of the Constitution to Jammu and Kashmir. So this was with respect to 370 clause 1. Another part of 370 was that it provided for a constituent assembly in Jammu and Kashmir. Article 370 provided for a constituent assembly for Jammu and Kashmir. Another aspect of the 370 has been the definition of state government. If you see the definition of state government, you see, explanation, for the purposes of this article, the government of the state means the person for the time being recognized with the President as the Maharaja of Jammu Kashmir, acting on the advice of the Constitutional Minister for the time being in office under the etc. etc. This Maharaja was later converted, changed into Sadar-e-Rayasat. Sadar-e-Rayasat. Simply something called a governor type by the Constitution of Jammu and Kashmir. So this Sadar-e-Rayasat, acting on the aid and advice of the Constitutional Minister, was the state government. The nomenclature of the Sadar-e-Rayasat was changed into governor, I think in 1970s. But essentially the state government means
That was changed by India.
by amending amending the presidential order 1954. Governor, right? So governor acting on the aid and advice of the council of ministers is the state government, not the governor per se. Right? But the most important aspect of this is this clause 3. This clause 3 will answer your question, although partially, with respect to this question whether Article 370 can be amended, repealed, modified, etc. etc. What does this say? Notwithstanding anything in the foregoing portion of this article, whatever is there earlier, notwithstanding means non-obstante clause. No. The President may, by public notification, declare that this article shall cease to be operative or shall be operative only with such exception and modification from such date as he may specify. Simply means President can declare through a public notification, like a proclamation, an order of the under the Constitution, that this article shall cease to be operative, which means it will be inoperative, completely or partially, whatever that might be. But this requires this condition, this is very important, provided that the recommendation of the CA of the state referred to in clause 2 shall be necessary before the President issues such a notification. Simply means the President can make it inoperative or apply with modification, etc. He can only do it or she can only do it when the recommendation of the CA is given. So until unless the Constituent Assembly does not recommend that you make it inoperative or make it with such exception or modification, President cannot do it. After the Constitution was made by the state of Jammu, the Assembly was dissolved. The question arose, this Assembly does not exist. This Assembly does not exist, hence does not Article 370 become permanent. This Assembly was dissolved. Now there is no Assembly. So without the Assembly's recommendation, you cannot make it inoperative or modify or amend what, right? Because no Assembly is there, does this not provided as a semblance of permanency to Article 370? Because the amendment, modification or cease to be operative, etc. require this. Does that mean Article 370 cannot be amended? Has Article 370 become similar to the basic structure of the Constitution?
More or less.
We'll answer this question later. Right? So this is the essence of Article 370. Now what is the linkage between Article 370 and the Constitution of Jammu and Kashmir? The Constitution of Jammu and Kashmir, Section 3 of the Constitution says that the state of Jammu and Kashmir is integral part of the India, etc., etc. Section 5 essentially deals with, Section 5 of the Jammu and Kashmir, 8th 12 Jammu and Kashmir Constitution, essentially dealt with the nature of relation between the Indian Constitution and the Jammu and Kashmir Constitution. In other words, this Jammu and Kashmir Constitution, Section 5, essentially cemented the framework of relation between Jammu and Kashmir and Union of India as provided in 370. Jammu and Kashmir Constitution, through its representative assembly, accepted the nature of relationship which exists between the Union of India through Article 370 with the state of Jammu and Kashmir. What I am trying to say is that the Constituent Assembly made permanent this interim arrangement of Article 370. Because this interim arrangement was till the time when the Constituent Assembly was instituted, it made a constitution, then it will decide the nature of relationship. So on a reading of the Constitution of Jammu and Kashmir, what we are getting is the nature of relation through Article 370 with the state of Jammu and Kashmir was cemented, was reinforced, re-emphasized by the Constitution of Jammu and Kashmir. In this manner, this interim arrangement became permanent arrangement.
So, but the word permanent in Article 370 of the Indian Constitution was not amended after the relationship between India and Jammu and Kashmir was finalized by the Jammu and Kashmir Constitution.
Article 370 has never been amended except this, what we say, the 2019 orders.
But sir, once the Constitution Assembly of Jammu and Kashmir, they finalized the relationship between these two, but that word permanent in Indian Constitution, Article 370, should have been amended, right? Because that the relationship was finalized by Jammu and Kashmir Constitution.
Where is the word permanent? It is, are you saying this temporary provision with respect to the state of Jammu and Kashmir? You are saying this temporary should be made permanent provision. That would have been only a change in the nomenclature. The essence is the same. Nobody would have thought that this situation will come in that way.
These people can interpret it.
Right. The temporary provisions is with respect to the context. It was to deal with the temporariness of the exact nature of relation between the government of India and the state of Jammu and Kashmir was not clear. There were multiple challenges, multiple issues at stake. So in order to provide, what do you say, a system of arrangement, it was enacted, it was incorporated into the Constitution of India. But Indian government made a commitment to the people of Jammu and Kashmir that the exact nature of relationship between the union and the state will be decided by the people representative through an assembly and their constitution. The constitution cemented the nature of relation between India and state Jammu and Kashmir. Because Indian constitution says Article 1 and 370 applicable to what? State of Jammu and Kashmir. So reading of Jammu and Kashmir constitution amply make it clear that they accepted the existing structure of relationship between the union and the state of Jammu and Kashmir. Remember, no other princely state had the option of an assembly. Right? So the provisions here are somewhat special. So that is why this word is being used, special provision, special status. But although there are these conditionalities, consultation, concurrence, assembly, etc., etc., before the 2019 presidential order, I'll come to that later, more than 90 entries in the union list have been extended, have been applied to the state of Jammu and Kashmir. More than 20 concurrent list subjects have been extended, made applicable to the state of Jammu and Kashmir. I think more than 250 articles of the Indian Constitution have been made applicable to state of Jammu and Kashmir. In none of these applications, the concurrence of the assembly was taken. Because remember, the concurrence of this assembly, where is it? Is only necessary for amending or making it inoperative. They have taken, they consulted with the state government and consulted with the state government. Majorly consultation with the state government, and state government said this is it, etc., etc. And if you see this extension, practically all the constitution parts have been extended to the state of Jammu and Kashmir. So from 1954 till 2019, the state of Jammu and Kashmir gradually lost its autonomy and became further more integrated into the Constitution of India, into the Union. Not all extensions are as per the spirit of the Constitution. There have been one instance where the consent of the governor was taken. Right, but you see governor, because Jammu and Kashmir was under governor's rule then. But ideally, governor acting in aid and advice. But in governor's rule, there is no council of minister. So governor appointed the central government. It has happened once, I think in late 1980s. But anyway, Article 370 survived, although not in substance but in shell. But along with Article 370, another article, Article 35A, also survived. Because in 1954, when the presidential order was first promulgated. First in the sense after which replaced 1950 preferential order, the mother order, the original order. This 1954 preferential order also added Article 35A to Part 3 of the Constitution, which provided some special rights to the permanent residents of Jammu and Kashmir regarding employment, property, scholarship and others, etc., etc. So Article 35A was there, although Article 370 per se has become more or less hollow. But still, because of this, there was no Constitutional Assembly, and hence Article 370 was neither amended nor made inoperative. This has been the situation before August 2019. Before explaining what happened in August 2019, let me tell you some political development which happened in 2018 in Jammu and Kashmir. It will take more than 1 hour. It's all 1640. But anyway, in 2018, the government in Jammu and Kashmir, a coalition government, PDP and BJP, this government fell. PDP Chief Minister of Jammu and Kashmir, Mehbooba Mufti, resigned. I think within a couple of days, or I would say not a couple of days, if I think the Chief Minister resigned today and tomorrow the governor's rule was imposed in Jammu Kashmir. Remember, governor's rule under the Constitution of India, under the Constitution of Jammu and Kashmir was for 6 months. So governor's rule was imposed in Jammu Kashmir. 6 months ended. When 6 months ended, the President imposed preferential rule in Jammu Kashmir under Article 356. This preferential rule under Article 356 has been extended for further 6 months. In between, general election happened in India. In August 5, 2019, the President of India issued Constitutional Order 272. So, remember, the Jammu Kashmir was under preferential rule, right? Under preferential rule, and the President issued Constitutional Order 272 by invoking the power under 370. The essence of Constitutional Order 372 has been, it replaced 1954 order. Replaced 1954 order. So whatever happened under 1954 order, it nullified. For 2019, CO 272 replaced 1954 order. Not only that, it made all the provisions of the Indian Constitution applicable to the state of Jammu Kashmir. Made all the provisions of the Constitution of India applicable to Jammu Kashmir. It made the state government as governor, which means the order made the governor of the state as state government. Simply means the state government will be the governor. The reference to state government under Article 370 will be reference to the governor of the state. State government became governor of the state. Not only that, it amended Article 367 of the Constitution. Article 367 of the Constitution was amended. A provision was added, 367 clause 4, if I am not wrong. This provision provided that, or this clause provided that, the term Constituent Assembly in Article 370 clause 3 would be mean Legislative Assembly. Remember, Article 367 of the Constitution means it's an interpretational clause, interpretation, meaning the various words are there in the Constitution. So what are the meanings of the Constitution? So in order to interpret the Constitution, the meaning of the words are necessary. The mean 367. So the Constitution can be interpreted through multiple ways. One is this Constitution, Article 367. So Article 367, they added by provision What was the provision? They said the word Constituent Assembly in Article 370 Clause 3 would mean Legislative Assembly. I will explain it further later, but for the time being, understand this. For the time being, understand that Jammu Kashmir was under preferential rule. Under preferential rule, the authority of the Legislative Assembly will be exercised by the Parliament. Next day, the government introduced a resolution in the Parliament. Resolution. What was the resolution? The resolution was to make Article 370 inoperative. Or put it differently, to make it to amend Article 370. Remember one thing, Article 370 has not been repealed, has not been abrogated. Article 370 is there in the Constitution, but in a different form. If you go home, find out if I can see. Let me see if it's possible. Constitution of India. No, this will not do. Constitutional order. 273. Yes, this one. Difficult to find this thing. खुल नहीं रहा है. I am operating 273, they are giving me 272. What to do is, you can see later, but let me see if I am able to get it. Keep this in mind. Article 370 has not been repealed. Should keep this in mind. Article 370 has been, the special provision to Jammu and Kashmir has been made inoperative. This can be the right way of looking at it. Or you can say the CO 273 has effectively made Article 370, the CO 273 has effectively repealed 370. Effectively repealed. Does not repeal per se. There is a new Article 370. But essentially, this amendment, this CO order, essentially it says that the special status available to the Jammu Kashmir is not available. But remember, not repealed, not abrogated. It has made Article 370 inoperative with respect to Jammu and Kashmir. Right? If I can see, I will show you that, but there is a problem with internet connection, yes. But anyway, so this resolution was introduced in the Parliament. This resolution done away with the special status which was available to Jammu and Kashmir. The Lok Sabha and Rajya Sabha passed this resolution. After this resolution, CO 273 was promulgated by the who? By the President. Why it is necessary? You see, in this 370, this proviso is there, na? Assembly. Now they amended 367, which says that CA means LA. Now LA under presidential ruled the parliament. Government had majority in both the houses. Both the houses passed the statutory resolution under as per 370 clause 3. Now after that, President public notification, Constitutional Order 2273 said federal status is removed. After some days, the government of India introduced a bill in the parliament, Jammu and Kashmir Reorganization Bill, which essentially bifurcated the state of Jammu Kashmir into the Union of Jammu and Kashmir, UT of Jammu and Kashmir and the UT of Ladakh. So the statehood of Jammu Kashmir was taken away. The state of Jammu Kashmir was converted into two UTs. UT of Jammu and Kashmir with assembly and a UT of Ladakh without an assembly. When these things were going on, individuals approached the Supreme Court, challenging essentially the CO 272 and 273 and the Jammu Kashmir Reorganization Act 2019. People approached Supreme Court in 2019. Supreme Court took almost more than 4 years, and it decided to hear the case in 2023. It heard the case. Everything was published. The hearing was transparent because it was live streamed. The people, the petitioners and the government, they got the opportunity to present their views. In December 2023, the Supreme Court announced its verdict. The Supreme Court of India upheld almost all the decisions of the Union except one. That we will discuss later. But for the time being, understand. The judgment of the Supreme Court upheld CO 272, 273, effectively abrogation of the Article 370 and bifurcation of the state of Jammu and Kashmir. Now I am going to show you some this judgment matrix, this one. These are the issues which the court discussed. Court framed some issues for its adjudication. So these are the issues and these are the verdict. I am going to give a brief explanation here, right?
Is it available?
It is not available. It is available here. You know what I am discussing, just make some notes, more than enough. You are not going to be a part of the review petition, isn't it? The people approach Supreme Court against this judgment. But anyway, your point of view should be what we say from the point of exam. But again, it's a very difficult topic, so you should have proper understanding also. But there should be limit to understanding. Issues. Does J&K retain its sovereignty? The point is that the state of Jammu and Kashmir, through Article 370 and its constitution, does it retain any sovereignty? Did it have any sovereignty? Sovereignty lies with the people. If you see the preamble, sovereignty, Indian Union. Indian Union is sovereign. No state is sovereign. Although I will see that later. So the question was, the petitioner said that although there was a constitution, you applied everything to the state of Jammu Kashmir, the Jammu Kashmir state had some internal sovereignty. But the court said no. Because the argument was, other princely state after signing IOA signed merger agreement, merged. So sovereignty subsumed in the larger union. But the J&K did not merge. After IAA 370, then the constitution. And the residuary power of lawmaking also existed with the state of Jammu Kashmir. And if you see the IOA also had some element of sovereignty, which the Maharaja said, I still retain some sovereignty. I will decide the nature of relationship between the state and you. But whatever that might be. Supreme Court said no. After that IOA, a proclamation was made by the Yuvraj Karan Singh, now the Karan Singh, son of Hari Singh, sorry. According to that proclamation, the court says the sovereignty, whatever element existed, was given up. The proclamation essentially said that the Constitution of India will be applicable to the state of Jammu and Kashmir, whatever that might be. But for the time being, understand that according to the Supreme Court, the state of Jammu and Kashmir did not exercise any sovereignty, it did not have any sovereignty. We are not in disagreement in this point. We have no problem. Because ultimately sovereignty, whatever that might be, should be with the union. We are not having any problem here. But we will, okay, we have problem. I will discuss that later. Don't worry. Was Article 370 intended to be a permanent provision? I will do one thing instead of doing this way. What I do is, I will go on criticizing each and every aspect. But, right, instead of taking criticism later, let us discuss the relevant points and see the criticism of them. What is this first one? Where is that first? J&K retains sovereignty. Although the word sovereignty is not there in the Jammu Kashmir Constitution, but the Supreme Court seems to have adopted what is known as constitutional monism. There are multiple states in India which have special provisions. In fact, the part 21 of the Constitution, right, 371J, A, B, C, F, etc., etc. Although may not be in the same manner with respect to Jammu Kashmir, others have. Supreme Court has said in SR Bommai case that states are sovereign in their assigned sphere. The concept of sovereignty is not a monolithic, homogeneous concept. Sovereignty does not mean that there exist two equally sovereign polities in a country. Sovereignty can be shared sovereignty. The Supreme Court says the union is the supreme one, the union laws are supreme, the union constitution will subsume everything. A monistic approach, looking at the laws at the top of the hierarchy as supreme and not giving any semblance of autonomy to other constituents. This is a very problematic approach. Because the Indian Constitution is not unitary one. It's a federal, or you can put it, if let's say cooperative federal or quasi-federal, whatever that might be. It is more federal than unitary. So in a federal system, states, whatever their relationship with the union was, they have some sovereignty. We are not a unitary country. In a federal system, states have sovereignty. So in Article 370, the extent, the degree of sovereignty might be more. Although the word sovereignty may not be there. The Supreme Court uses a word. 370 does not epitomize sovereignty, but something called asymmetric federalism. It's a word play. The point is that asymmetric federalism means the nature of relation between the union and with its constituent units are not uniform. Special category states are there. In the Constitution itself, you have the special provision for states. So, asymmetrical. We have UTs, etc., etc. But whatever that might be, the point I am trying to make is that the reason the Supreme Court has looked into Article 370 and said that Jammu Kashmir did not have any sovereignty, it is because of the monistic approach of interpretation. And the philosophy of constitutional monism permeates the judgment of the Supreme Court in Article 370, which will have implications not only to the issue we are discussing. It is creating an approach where whatever the union does will be supreme. And the local law, the state laws, all these are subordinate to that. That is not the arrangement in the Indian Constitution. This constitutional monism, this philosophy, we will find later also. In the context of Article 356, etc., etc., we will discuss that. But the point is that even when the Article 370 does not say, or the Constitution of Jammu and Kashmir does not say that they have sovereignty, does not matter. But you should follow what Article 370 says. The manner of bringing COs 272, 273, etc. are not appropriate. We will discuss that later too in the next portion. But whether J&K had constitution sovereignty or not does not matter. But what matters is the approach the court takes through constitutional monism to reach that conclusion that it does not have. It's a very problematic approach. It's a centralized approach. It provides more weightage to the centralizing tendency of Indian Constitution. It makes the union more strong. It undermines the federal principles. Was Article 370 intended to permanent provision? Permanent. No, the purpose of the provision was to accommodate the special needs of state with a complete integration. According to the Supreme Court, not a permanent because it provides some arguments. One is the textual interpretation of the Constitution. Textual. 370. Textual. Temporary provision. So, textual interpretation of the marginal note of 370, temporary. So, it's temporary. So, there is no question of permanency. Not only that, they say 370 has been interim arrangement through which the state can be fully integrated to the Indian Union through a collaborative process. Supreme Court says this, collaborative, this consultation, concurrence, etc. They use this term, collaborative. So, Article 370 essentially was there in the Constitution to completely integrate the state of Jammu Kashmir into the Union. So, once this integration is achieved, then there is no need for 370. So, textual interpretation and this collaborative approach. It says that Article 370 is a temporary provision. But we are saying that Article 370 is not a temporary provision. But we are also not saying that Article 370 cannot be amended. We are not saying that Article 370 cannot be repealed. You can do it. There is a provision here. You use this and you do it. But the manner which you have done is not correct. I am saying that the question of Article 370, whether they are permanent or temporary, can be addressed later. If you want to remove Article 370, there is a provision in Article 370 clause 3, you should follow that. But the orders of 272 and 273 did not do it. So it is constitutionally suspect. Now the actual question, whether it is permanent or temporary. If you read Article 370, its enactment, incorporation, and its provision for a Constituent Assembly of Jammu and Kashmir, and the Constitution of Jammu and Kashmir, and Section 5 and various other provisions, which essentially meant that Jammu Kashmir Constituent Assembly and Constitution made Article 370 permanent. Permanent in the sense that permanent with respect to the nature of relation which Article 370 defines. This way it's permanent. We are not saying that Article 370 cannot be repealed or can be made inoperative. You can do that. That's not the question. The question is, Article 370 has become permanent to the extent that it re-emphasized the existing nature of relationship between union and the state. So Article 370 defined the relation, which was also acknowledged by the Constitution of Jammu and Kashmir. In that it was permanent. And if you want to amend it, remove it, there is a provision here. You could have done that. Can the President abrogate Article 370 without the recommendation of Constitutional Assembly? Remember, 370 clause 3 says what? Provided, what is that? This one. Recommendation of Constitutional Assembly. No Constitutional Assembly. No Constitutional Assembly. So without Constitutional Assembly, can the President use this power under Article 370 clause 3? The Supreme Court says yes. It says, can the President abrogate Article 370? The word abrogate is used, but don't worry. Without the recommendation of CA, yes, the President has unilateral power under 373. The President is not bound by limited by recommendation. What the court says, the proviso to Article 370 clause 3 is only recommendatory. It's not mandatory. It's not binding on the President. So even if the CA existed and it did not recommend, does not matter. President had the unilateral power to abrogate the 370. Even the President, when it issued the constitutional order, did not think about such an interpretation. It was Supreme Court which found out this, because I'll explain that later why it is so. The point is that the Supreme Court says without recommendation of the CA, President can unilaterally abrogate, because you see the Constitutional Assembly does not exist, but not existence of Constitutional Assembly does not undermine the power of the President. President is there. President has the power. Even when there is Constitutional Assembly, President has substantial power. Recommendation is not binding. It has unilateral power. So he can do it. Now the problem is this here. If the President can do it without the Constitutional Assembly, why did the CO 272 amended Article 367 and made it and changed CA to LA? Because when the President issued it, the government knew that they did not have the power to do it. That is why they amended 367. But Supreme Court has provided a way to the government. The government did not even argue this. As far as I know, the Supreme Court provided a way to the government. The purpose of the Supreme Court judiciary is to adjudicate dispute, not act as an advocacy group to the government. It added words into the mouth of the government to this judgment. Because the government knew that until unless CA is there, we cannot do anything. They could have amended Article 370 through 358. That's a different question altogether. They don't do it. What they did, they amended 367 through preferential order. Supreme Court nullified this amendment to Article 367. Remember that. Partially, while the Union used Article 367 to amend unconstitutional. The President of India, through CO 272, amended 367. Right? Converted CA to LA. Because the Jammu Kashmir state was under preferential rule, LA became parliament. And then 273 was passed because of the resolution passed by the parliament. So the fundamental basis of this entire exercise has been conversion of CA to LA, which the court has struck down. They say you cannot amend this manner. If you want to amend a provision, use the proper amendment procedure. Not this manner. Now, the most surprising thing is that the court has invalidated this particular amendment through that order. But it went on to uphold the other consequences. It comes out with a very, very surprising theory that the President has unilateral power. Recommendation is not necessary. There is no CA. Substantial power. Now, what kind of argument is that? What if the text of the Constitution says? This interpretation of the Supreme Court has no logics to stand on. It has no legs to stand. The logic is convoluted at best. Because simply says recommendation assembly shall be necessary. It does not say recommendation is binding or not. That we are not concerned. If it says shall be necessary, then it should be necessary. We cannot read shall as may. The interpretation is absolutely totally wrong. In any case, CA is not existing. If CA is not existing, how can the President have the power? Because presidential power is with respect to this. If there is no CA, then you could have established a Constitutional Assembly. Or you could have amended Article 370 through 358, which you could have done. This is what Fali Nariman says. The manner of amending is not correct. You could have amended this. Nobody is saying Article 370 cannot be amended. You could have amended through the constitutional procedure. All the Supreme Court has nullified, invalidated that inclusion in Article 367, but it went on to uphold the consequences of that amendment.
So, one doubt. So, why they went through all this hassle of amending Article 367 when they could have simply done under Article 368?
Under Article 368 require two-third majority present, etc., etc. They thought that they did not have that. That might be the reason. I have to.
Actually, they were having it. In Rajya Sabha, they were having it.
They believed that. You see, when this happened, I told to students, I have no hope that the Supreme Court will nullify the decision of the Union. Because if you see the trajectory of this court, it has become more executive minded. That's true. It is not going to do it. But what I was hopeful that it would have at least done or adjudicated the issue of downgrading a state to UT. Unfortunately, that it did not do. So to answer your question, the union would have thought, does not matter, whatever we do, the court is going to give its stamp of approval. It had the confidence. Or put it differently, it might not have, it wanted to do things secretly. Secretly, if you bring this, right, it would have created a lot of discussion, debate, etc., etc. Whatever that might be, whatever their motivation might be, I can't look into the minds of the government of India and see their motivation. What I can say is, the way they have done is absolutely incorrect. And the upholding of the Supreme Court, this particular aspect is also erroneous. The cause is LA, CA became LA, and the consequence is repeal. The cause you struck down, but you upheld the consequences because you invented another theory saying that President has unilateral power. It is not recommended, it is not mandatory. What is the purpose of having a provision in the Constitution? Does it mean that the court, the judges, by applying their own motivation, can they apply their own perception? Or can they interpret the Constitution without having faith on the text of the Constitution? This provision is given for a purpose. Because the recommendation, it's a process, it has to be followed. You did not follow. But the court says, even if you have not followed this process, does not matter. Because the consequences would not have been different. Had there been a CA, the CA did not recommend, does not matter. President can disregard this recommendation. The President of India has become more powerful after the judgment of Supreme Court in Article 370. Now this one, is CO 273 valid? Now this is, you see, collaborative exercise, President could not act maliciously, etc., etc., etc. The reasoning is same. CO 273 was as after the resolution passed by the Parliament, which acted as legislative assembly. CA, LA, presidential rule, Parliament, statutory resolution passed, CO 273, which effectively abrogated, made Article 370 inoperative. Supreme Court says it is valid. But if you see Article 370 clause 3, then CO 270 does not have any legs to stand on. Not only that, in CO 272, In CO 272, the state government became governor. State government became governor of the state. Governor of the state was appointed by the president, that is union. In CO 272, president issued proclamation. This proclamation either required consultation or concurrence. State government. Who is the state government? Governor state government. But governor is appointed by president. It was under the presidential rule. So effectively president. So president took concurrence from president itself and they issued proclamation. Are you getting what I am trying to say? 272. This is another point which I wanted to add in 272. Governor became state government. Right? But under presidential rule, it is the president. So president effectively took consent from president and president issued proclamation. Can there be any other example of violation of what do we say, conflict of interest doctrine? I am taking consent from my own and I am giving an order which has huge ramification. Article 273, CO 273 according to the court is valid because the recommendation is not mandatory. But again, I am repeating this point. The recommendation, whether it is mandatory or not, there is a process which has to be followed. This recommendation not mandatory will have another issue. We will see that later. Simply, you see, this judgment, the way the Supreme Court has validated CO 273, again I would say it has no logic. It has no constitutional basis. Because the fundamental idea was fear to LA. Fear to LA you cancelled. Now from where you got this idea that this CO 273 is valid? You said president has unilateral power. Shall be necessary is the word. Necessary, it has a meaning, not necessary, not may. So that is the reason scholars, they say that this reasoning cannot be accepted. Not only this is again a fundamental, I would say, ominous threats to the federalism of this country. Threats to federalism. Supreme Court has felt that federalism is the basic structure of the constitution. I think the judges who heard this case have forgotten that principle. Can the president take irreversible decision during the proclamation of president rule under 356? Yes. What does it mean? One state under presidential rule. Can the president take any decision with respect to state? Here in the context of Jammu Kashmir, what happened? Jammu Kashmir Reorganization Bill. Presidential 356. Parliament became LA. So the parliament, the executive, the president, they can do any act. President acting on the aid and advice of the Council of Ministers, meaning executive, and the parliament can take any unilateral decisions, any actions which will have irreversible consequences. Which simply means the JNK, if they converted or if they removed the provisions of 370 or they converted a state to UT, this according to Supreme Court it can be done. President must have the power to take any action with respect to object of proclaiming presidential rule. It is true that president should have the power to take some decisions. Why? But the fundamental question is, why presidential rule is established or invoked in a state? Breakdown of constitutional machinery. Right? Hence the decisions taken by the president should be having nexus, relation with the objective of the proclamation. The objective of the proclamation that is imposing presidential rule is to prevent breakdown of machinery, to restore machinery. So your action, decision, legislative or otherwise, should be in consonance with this objective. Essentially means you could not have taken any other decision which violate this objective. The Supreme Court says the president or the parliament for that matter has almost absolute power. Any action can be taken. Not only that, what about challenging this action? Supreme Court says all actions taken by all decisions taken by the President or the Parliament are not open to challenge under judicial review. Why is it so? Because if every decision has been challenged, then there cannot be any possible governance in the state. There will be chaos and uncertainty. Accepted. Fine, you cannot challenge everything. But you can challenge at least some important aspects. What more important aspect can be there apart from this? That you have converted a state to UT and you have issued. The entire power of the state assembly, the ministers, have been taken by the parliament and the president. And you have kept on changing the character of the state. Can this be done? The governor's proclamation of rule in 2018 laid the presidential rule. Whether this proclamation were to restore constitutional machinery in the state or to revoke Article 370. You cannot use 356 proclamation to revoke 370. If that was the object, then there is no relation between it. The Supreme Court has said during 356 anything can be done by the Parliament and the President. It means that what happened with Jammu Kashmir can happen with other states. Any state can be demoted, any state can be bifurcated. The Parliament can take any act decision, legislative or otherwise, executive action can be taken. I give you an example here. Under Article 358, there are two amendment procedures. One is having at least consent of the state assembly, right? At least half of the state assembly. Conflict situation where the union does not have this majority. What can they do? Impose 356. The assembly became parliament. Parliament will act on behalf of the state. Multiple things, policy division, interstate agreement, anything can be done. So the Supreme Court judgment in Article 370 has expanded the scope for abuse and misuse of Article 356. It violates federal principles. You should read this particular point with respect to Article 3 of the Constitution. I'll explain. This one. These 2 points are related. Was the reorganization of JNK into 2 UT constitutional? Procedure is valid, no need to decide valid, etc., etc., etc. Now, Article 3 of the Constitution says, Article 3 provides for reorganization of state. Right? Article 3 does not say you can convert a state to UT. You can carve out a UT from a state. You can decrease the size of the state, increase the size, name, etc. You can do that. Article 3 is silent on who? On whether state can be demoted to UT. So Article 3 does not provide any scope for that. Neither any part of the Constitution provides the scope for demoting, converting a state to UT. No, but the Union did that. The Supreme Court did not adjudicate this issue. It should have adjudicated. It did not adjudicate. Why? Because according to the court, Article 3 provides for reorganization can happen only when you pass that bill. You send that bill to the Constituent Assembly. It is true that the recommendation is not mandatory, whether it is given in time or not. But this is mandatory. The process is mandatory. Like in 370 clause 3, Supreme Court said, not recommendation is not mandatory, nothing. Same argument, same logic or illogic is found here. It says Article 3, fine, as it is not recommended, the recommendation is not mandatory on the union. Even if you are not sending it to the assembly, that does not matter. What can you say? For what purpose these provisions are there in the Constitution? If this is the interpretation of the constitution, they will interpret this part 3 of the constitution. Part 3. They will say fundamental rights. No, there is no fundamental like this. We are interpreting in this manner. They can do that. Whether they will do it or not is a different thing. What this judgment has done is that it provided, I would say, it aggrandized the power of the executive at the union level.
So, but the carving of Ladakh from Jammu and Kashmir and making this as a UT is fine. But demotivating.
It's not fine. I will explain. It upheld the carving out of UT of Ladakh. Now, let me ask you one thing. This requires, you can carve out a UT from a state, but whatever geography you are doing, it requires at least the bill to be sent. Sending the bill, concerned bill to the concerned assembly is mandatory. This procedure has to be completed. This procedure has not been completed. Why? Presidential rule, no LA. Under presidential rule, LA became parliament. Parliament passed it. So parliament passed means parliament, the requirement is done. The passage, the sending of the bill to assembly was, the procedure was fulfilled because parliament acted as assembly. But if you read this particular aspect with respect to 356, absolute power to the union, the president, this cannot be, this violates federalism. Any state can be brought under 356 and any change can be made on the character of the state. The Supreme Court did not adjudicate this issue. It said the Solicitor General of India assured that we will restore the statehood of J&K. Now let me ask you one question. If it is legal, constitutional for the state to be demoted to UT, why would the union say that we will restore statehood? Or can the court decide a case merely based on an assurance given by an officer of the union? Article 3 is a legislative act, which means Parliament will have to do it, not the Solicitor General. Parliament is not bound by the Solicitor General's opinion. Parliament is not bound by the Solicitor General opinion. And you cannot simply evade answering a very important constitutional question like this. The Supreme Court says, we are not addressing this issue whether a state can be demoted to a UT. We will address this question in a more appropriate case. Can there be a more appropriate case and apt case than this? Cannot. The most consequential case is this. The union can do the same procedure. They will do. They can do. And when people challenge in the court will say, okay, you see the FG and AG is saying it can be done, and we will decide this issue in next case. It can go on. Prevarication. Total capitulation of the court before the executive. At least this should have addressed. Leave alone Article 370. Leave alone Article 370. This is a great, important question, having significant constitutional locus. Should have been this is a huge, immense significance as far as the federal principle of this country is concerned. So any state can be brought under 356 and you can do anything. What are the need of states in the country then? Why do you need to have the federal system, federal principle in the constitution? What sanctity is there for the federalism as a basic structure of the constitution after this judgment? The court should have addressed this question. It upheld the validity of carving out of UT of Ladakh. But as far as demotion is concerned, it said, we will see later. In a way, the Jammu Kashmir bill did two things, demotion and separation. Without demotion, can you separate? Without demotion, can you separate? You can separate. But for that, assembly is required. The reason preferential rule was extended is to make the parliament as representative of the LA. Here you will never see the people of Jammu Kashmir. The people of Jammu Kashmir, the representative political institution in Jammu Kashmir have no role. Where is representative democracy? Where is responsible government? Where is democracy for that matter, which is a basic feature of the constitution? Where is the voice of the people of Jammu Kashmir? It is not only Jammu Kashmir per se, it is other states also. This should have been addressed. Whether it is correct or not, the Supreme Court knew it is not correct. It did not want to confront the government of India. I don't know why. When the remission judgment was being taught, I was happy with respect to the Supreme Court. But you see what is happening here. They said we will adjudicate this issue later. When will you do that? The Chief Justice of India will retire and somebody else will come and he will say, I will do that later. It took 20, 21, 22, 24, more than almost 4 years. You let these things happen. First of all, you did not adjudicate this issue promptly. You delayed it. 4 Chief Justices did not do. Now once you do it, you did it in this manner. They said election should be completed before 30 September. Why 30 September? And why didn't you keep a timeline for restoration of statehood? Clever, na? They are clever. They should have taken assurance from the FT for that matter. Yes, tell us, this is the date. Or this. They did not provide any timeline for it. They said there should be this. Our concern is not much with Article 370, but our concerns are more with these aspects, which are unconscionable, which cannot be accepted. Supreme Court cannot say we will not apply judicial review, we will wait for an appropriate case. What more appropriate case can be there than this? And the Supreme Court's purpose is to review the actions of the executive. It cannot say all different cannot be reviewed. You should accept it. And if you find that these reasons are based on merit, fine. You cannot say that we will not hear it. That is not your purpose. You have to hear the cases, especially this one. And you also know what the government did when this preferential rule was imposed in Jammu Kashmir, in the shutdown, etc., etc., etc. So the delay helped the government. When the judgment was given, also helped the government. The only thing was the amendment procedure with respect to 367 was nullified. But it was a free rope, a long rope, I would say, long rope to the government. The government would not have thought that this many scope is there. They did not have belief that itna power hai hamare paas, hame to pata nahi tha. The court is putting words into the union. Why are you not doing this? Ye hai tumhara power, ye dekho, all these things. Is their job? No. Their job is to check the institution of power. The court is supposed to check, prevent the aggrandizement of power of institutions. But this judgment has aggrandized the power of institutions, expanded the power of institutions in this country. The court has failed in its duty to limit the power of the state. Constitutionalism become a casualty in this judgment. Does the JN Constitution survive application of 370? No. So JNK Constitution also did not survive. So Indian Constitution is applicable in full to the Jammu and Kashmir. Jammu and Kashmir does not have special status under 370. It has been demoted, converted into UTs. Supreme Court said, we will not do anything at this point in time, right? And we'll wait for appropriate case. Whatever the government does with respect to state under preferential rule, it has near absolute power on that. We cannot restrict this power of the President. Even if President can take irreversible. The word is huge. The import of the word irreversible efficient. What? I mean, what? Anything can be done. The purpose of 356 is not this. Article 356 has been criticized for misuse. SR Bombay judgment and various of the development have prevented the misuse of Article 356 to some extent. But this judgment in Article 370 has opened a Pandora's box and provided opportunities for exploitation and misuse of Article 356, especially when the government has majority in both the Houses of Parliament.
Is this nullifying SR Bombay case also to some extent?
If you read SR Bombay with 356 and federalism, yes, it seems that it violates the principle, the philosophy, the constitutional basis of SR Bombay judgment. SR Bombay says if the preferential rule, this JR is applicable, malified, etc., etc. Another issue is that you see, the petitioners challenged the governor's rule, preferential rule, etc. The Supreme Court did not look into it. Had it looked into it, then the entire exercise would have crumbled down. The Supreme Court says in this judgment that petitioners did not challenge the proclamation of preferential rule and governor's rule, etc. But it is not correct. Petitioners have challenged it. The Supreme Court did not look into that in its judgment. It did not look into it. A grave error, a mistake, I would say. More than a mistake, or a genuine, I won't say genuine, or a deliberate one maybe. Because had that been the case, then the entire system would have crumbled down. Because there should be a rational nexus between the object of proclamation and the decisions taken under 356. The question is this: whether you impose preferential rule to revoke 370 and to demote it to 2 states, these have no rational nexus. They did not look into that question. They should have. If had that been done, then it had no legs to stand on. But the court is more innovative than you and me. They would have invented other reasons and would have provided an escape route to the government. What else we can say? Apart from that, have the judgment did anything good? We discussed the bad and ugly. Can we say there are some good points, good aspects of judgment? Yes, there is one. One is that it prevented the abuse of amendment procedure, 367. Prevented. So it emphasized, underlined the importance of procedure. But in all other aspects, it ignored procedure. Right. But here, क्या कहते हैं उसको? Yes, silver line in cloud. What? I am not getting the phrase properly. Some bright spot is there. We are discussing some bright spot because we are going to write an answer, and there are some there. There are some, but these bright spots are no consolation for us. One is that they say amendment procedure should be followed. Number one, that's fine. Second, they said one judge says it requests, suggests the government of India to come out with Truth and Reconciliation Commission. Truth and Reconciliation Commission. Always truth and reconciliation. Like it happened in South Africa. Truth and Reconciliation Commission. Reconcile. The commission essentially will deal with the aspects of problem, etc., and let the past be past. Let's move forward as a community, as we are Indians. This is the essence of it. The idea behind TRC is to establish peace. But you should always remember, there cannot be any peace without justice. S.K. Kaul, the judge, I did not expect from him this conquering view. At least I would have expected a dissenting judgment. The problem is with the master of roster. Because it is the Chief Justice of India who set up this bench. Had Justice Nagaratna, like people were there, I mean, they would have, probably, I would say, dissented. Unfortunately, there is no dissent here. Anyway, Truth and Reconciliation Commission. So the government can set up, right? Because the judge might have felt that I am doing an injustice through this judgment. So let us provide some consolation to me. Anyway, that's one. Second is that this election, right? Election should be conducted. I'll answer, Akshada, 1 second. Election, right? Because from 2018, there has been no representative institution in Jammu Kashmir. Third was that the FG, the Solicitor General. I request the Solicitor General, right, to honor the promise or what is the commitment. Please advise the Government of India to restore statehood. Right. Apart from that, the review petition is being heard in the Supreme Court. Not being heard. Whenever it will be heard, I don't know. They will hear it.
Have they accepted the review petition?
Reviews are right for you. Reviews are right.
But it is the discretionary of the bench.
No. Reviews are right. Whether they will accept or you review and review the decision, it's a different thing.
That's what I'm asking. Whether the court accepted it or not.
See, this review petition is filed. This is what I know. Right? And as you know the philosophy of the court, you know what you can expect. But nothing prevents you from being optimistic. Apart from this, you see, yes, another issue is that although the court says that the President, the Parliament can take any action under 356, it is subject to judicial review. The court says that judicial review is applicable. Where it is applicable? If the decisions have no right nexus with the object of the proclamation. Pradha Bhanu Mehta. You know Pradha Bhanu Mehta? Pradha Bhanu Mehta says, we are living in an era of future adjudication. Or let's say we are living in an era where principles evolved in a case are not applicable to that case, but to a future case. This case says judicial review is applicable, where decisions have no nexus with the proclamation. That principle should have been applied here. You did not do it. It has opened a flight window for you and me and others. Even if the government can take any action, there is an option that you can go. But it also says it is for the petitioner to prima facie establish that these actions are mala fide, malicious intent. Once you establish it as a malicious intent action, then the burden shifts to the government to prove that it is not malicious. Who will go? When will the court hear? Which judge will hear? Whenever it will happen, we do not know. But again, see, these are some points, important aspects which have emerged from this judgment. But apart from this constitutional aspect of the judgment, Jammu Kashmir has, there are issues in Jammu Kashmir. So scholars suggest that the formula which evolved through by A.B. Vajpayee and Manmohan Singh, you must have heard about this MM formula, Manmohan Singh, Musharraf formula like that, demilitarization, soft border, something like that. But anyway, the point I am trying to make is this. Issue of Jammu Kashmir not only requires constitutional, political or legal solution. It requires warm approach, winning hearts and minds. Isn't it? Because the people in a democracy are absent in this entire system. You can say that parliament is representative, but what about state then? If parliament is representative, then we could have been a unitary state. What for the purpose we have assemblies? This judgment centralizes the power in the union. It undermines the importance of federal principles. It provides greater power to institution. It dilutes checks on the institutional power. It aggrandize the power of the parliament. It undermines the powers, authority of state governments. In fact, it excludes the people from those decisions which have huge significance upon their life and liberty. Anything you want to ask, you can. Sir, it is true that after removing Article 370, of state like terrorism, employment, etc. According to the government of India, employment has increased, tourism has improved, people are happy, terrorism has decreased.
Happy without internet. Happy without internet.
Right. But you also see that there are other instances, terrorism, migrants are being targeted. There is the prophetic government there, right? So there are issues also. This is the notion that has been fed into people's mind. That is why we are discussing these aspects. You see, there are issues which need to be addressed. The judgment does not set a good precedent, right? And if the court has conscience, they can review it and address some of the major concerns, right? It can do. Otherwise, whenever an appropriate case comes, you should lay down the law.
Sir, as you said, previously Chandrachud later bench have given very good judgment, which is maintaining the balance of power between the institutions. But this is they are having slow flow. So based on this, can we say the judiciary is?
You see, judiciary, you have to see multiple aspects. Not only one judgment of the Supreme Court. It is generally said that whenever the union is against the respondent, the Supreme Court has been very slow, or in fact has taken decision to favor it. If you see, not only in the court of judgment, but the delay in deciding cases. Electoral bond, long delay, they heard, no judgment. Right? PMLA, the judgment of the Supreme Court has emboldened the ED. So multiple, with respect to adjudication, you can say to some extent, to a great, and what about appointment? Collegium system is there, na? Multiple appointments were re-recommended, reiterated by the collegium, not acted. The collegium is happy. There is a problem here. Appointment is so appointment, the collegium system, appointment, transfer, etc. Transfer, high court judges, no, not transferred. So they are merely recommending, reiterating, nothing is happening. Government is picking and choosing. So this means that the government has power over the court.
Sir, once the judiciary re-recommends a name for the judge, then they have to appoint.
They have to appoint, but they have to appoint, na? They have to. The judiciary cannot do it. There are a large number of people whose names have been reiterated, not appointed. Multiple individuals have revoked their consent to become high court judges. Some people, they appoint very fast. Some people never appoint. Saurabh Kripal. Multiple individuals are there. Their names have been reiterated multiple times. Transfer recommended. High court judges from Gujarat, not transferred. I think 4 or 5 are there. Justice, Chief Justice of Odisha High Court, Muralidhar, was recommended to be transferred as Chief Justice of Madras High Court, not transferred. Acting Chief Justice of Madras High Court was recommended transferred, not transferred. Multiple pending.
So they are not obliged to follow the.
Court should wield the stick. It should crack the whip.
But they are not doing it.
They don't want. They are pusillanimous. Sorry for this word. They seem to be having some kind of attitude of compromise. They don't want to take on the government.
Or can we say that judiciary system is slowly failing in our
No, see, your view should be in the context of question. Right? There are multiple challenges which need to be addressed.
generally, sir?
Generally, I will answer after this class is over. This is not required for your examination. This is the notion of the has been. Anything else, Akshita? people's mind, yes, perception matters these days, right? Especially in the context of social media. But yes, there have been improvement as per the government, and we believe and trust our government with it. But there are also issues of attack on migrants and attacks against security forces, etc. So the best thing would be TRC, recommended by SK Cole. Let the government of India reach out, right? Whatever happened, happened. Let us move forward, right? So we cannot have a hostile relation if the people are not, let's say, having people do not accept. You cannot control a people for a long time. Especially in democracy, you cannot do it, right? So it's better to integrate them, to address their concerns, talk to them. So for the primary thing is to have the state election. I would say before state election, let the statehood be restored, then state election. If question is asked in exam, how to make it sound positive or make balanced approach in respect of question, you provide me the question. Question about Article 370. If let's say 370, yes, the Supreme Court has upheld the the decision of the Union, although it has curtailed the misuse of amendment power and also provided a window of opportunity for setting up opportunity for, let's say, restoring statehood and conducting election. The Union should take steps in order to give effect to these suggestions and directions. Also, as recommended by the court, a Truth and Reconciliation Commission can be set up, which can address the issues of justice and restore peace. And both state and Jammu and the people of India and we all together can move forward then as a country. Anyway, this is it. Depending upon the question you write, don't have to take a negative point of view. If Article 370 can be used when, let's say, the court is not deciding question, there is huge delay, and the court is helping the executive, etc. You use Article 370 example. It is held that the Supreme Court has expanded the power of the Union with respect to states in the context of Article 370 judgment, and there have been criticism against Article 370 judgment of, let's say, of the court, as the court did not use the power of judicial review. It provided a long rope to the the Union. It has undermined principles of federalism and democracy, etc. As an example, can also be used. There is multiple application. Right? Anything else?